Hello students and welcome to the lecture. So students, as we know that we are covering the parliament, okay? And basically these are the topics that we have scheduled for the discussion under this particular series, like the introduction, organization of parliament, composition of two houses, system of election to the Lok Sabha, duration of two houses, membership of parliament, presiding officers of parliament, leaders in parliament, sessions of parliament, devices of the parliamentary proceedings, legislative procedure in parliament, joint sitting of two houses, budgets in parliament, multifunction role of parliament, ineffectiveness of parliamentary control, position of Rajya Sabha, parliamentary privileges, and the sovereignty of the parliament. Okay, so these are the topics. Out of this, how many we have covered? Introduction part, we have covered. Organization of parliament, we have covered. Composition of two houses, we have covered. System of elections to Lok Sabha, we have covered. Duration of two houses, we had covered. The topics we are left with are the membership of parliament, presiding officers of the parliament, leaders in parliament, session of parliament, devices of parliamentary proceedings, legislative procedure in parliament, joint sitting of two houses, budget in parliament, multifunction role of parliament, ineffectiveness of parliamentary control, position of Rajya Sabha, parliamentary privileges, and the sovereignty of parliament. Okay, so that is the picture that we have created together. All right. So basically, if we talk about the previous lecture, so we had covered the duration of two houses. Okay, in which we had seen that basically, if we talk about the Rajya Sabha, so the tenure of Rajya Sabha is 6 years, and if we talk about the Lok Sabha, the tenure is for the 5 years. Okay. Thereafter, we had discussed that this tenure of 6 years is not provided by the Constitution, but provided by the Parliament. All right. And if we talk about this 5 years, so remember that this could be, you can say, dissolved before completion of 5 years. Okay. By the president of this country. All right. Thereafter, we had seen that there could be the extension of 1 year granted to the Lok Sabha during the time of national emergency. Okay. But if the national emergency was revoked between this 1 year, then the tenure would only for the 6 months from the date of revocation of national emergency. Thereafter, if we talk about this 6 years, so this is provided by the People Representation Act 1951. Okay, so that is the things, or you can say these are the things that we have covered in the previous lecture. Now, after making the revision, let's start with the new topic, which is the membership of the parliament. Okay, how you could be the member of parliament, or in short, how could you person be the member of parliament or MP? So first thing are the qualifications, like what should be the qualification the person must have so that he could be elected for the parliament. So the constitution lays down the following qualifications for a person to be chosen as the MP or the member of the parliament. The first condition is very basic, that he must be a citizen of India. It means that non-citizens or foreigners, non-citizen or foreigners could not be, you can say, elected for the member of parliament. First thing. Second, he must make and subscribe to oath or affirmation before the person authorized by the election commission for this purpose. In his oath or affirmation, basically he has to promise or swears that he would bear truth, faith, and allegiance to the Constitution of India. First condition, he will uphold the sovereignty and the integrity of India. The second condition, and thereafter he must be not less than 30 years of age in the case of the Rajya Sabha and 25 years of age in the case of Lok Sabha. Okay, so there is a minimum age criteria provided for the members of parliament. For the Rajya Sabha, thereafter for the Lok Sabha. And what is this age criteria? For Rajya Sabha, the person must be at least 30 years of age. For Lok Sabha, the person must be at least 25 years of age. Thereafter, he must possess the other qualification prescribed by the parliament through the various acts and regulations. Okay. So if we talk about it, the parliament has laid down the following additional qualification by the Act of Representations of People Act 1951. Please correct the previous one. I had told you People's Representation Act, but in actual it is a Representation of People's Act. So please correct this. So the first condition is that he must be registered as an electoral for a parliamentary constituency. This is the same in case of both, whether it's a Rajya Sabha or the Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an electorate in that particular state was dispensed with in 2003. In 2006, the Supreme Court upheld the constitutional validity of this change. All right. Thereafter, the second thing is that he must be a member of scheduled caste or scheduled tribe in any state or union territory if he wants to contest a seat reserved for them. However, a member of scheduled caste or scheduled tribes can also contest a seat not reserved for them. It means that if we talk about the reserved seats, okay, which basically based on the population ratio. All right. So basically, the candidate who belong to that particular scheduled caste or scheduled tribe, only that particular person could conquers for that particular seat or that particular reserved seat. Okay. If the person do not belong to that particular scheduled caste or scheduled tribe, then he could not conquers from the reserved seat. Additional to that, if the person belongs to that scheduled caste or tribe, but he wants to conquer from the unreserved seat, or we could say as a general seat, then even he or she could conquer for it. Okay, remember this thing. After seeing the qualification, now what are the disqualification? Like on which grounds the person could be disqualified to be the member of parliament. So basically, if we talk about it, under the constitution, a person shall be disqualified for being elected as a member of parliament on these following conditions. If he holds any office of profit under the union or the state government except that of a minister or any other office accepted by the parliament. Okay, like we had talked about, whenever we talk about the government. So at the central level, the government isn't part of the parliament. Okay. And we know in parliament, whosoever will having the majority, that will make the government. Right? It is a very common thing. So the government having its head, which is known as the head of the government, and which position will be declared as the head of the government? The Prime Minister of India will be declared as an head of the government. Got it? That's the thing. And this Prime Minister could alone not run a country. That is very obvious thing. So that's why he will having its own council of ministers. What does it mean? It means that basically to assist him in running the countries, there will be so many ministers who will be appointed in the council. And these ministers will having the charge of particular ministry with sort of autonomy, right? And these ministers will run their particular area. Okay. And out of these ministries, some of the ministries are office of profit. Okay. Like if we talk about the railway ministry, transportation ministry, atomic energy ministries, and all right. So basically, if the person holding any of the ministry and basically they are part of that particular council of minister, all right, then the person will not be disqualified on this ground. But if the person not holding any ministry or exempted office, then the person will be disqualified if he holds any office of profit under the union of the state government, which is neither the ministry nor the exempted office. Okay. Thereafter, another condition is if he or the unsound mind and state so declared by a, like if the person, whether he or she is not in his or her senses, okay, then he could not be eligible to be the part of the legislature which runs this country. All right. And if this thing even declared by a court, then the person will be disqualified. Thereafter, if he is in discharge insolvency, then the person will be declared as a disqualified member to be the part of the membership of parliament. Thereafter, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to the foreign state. Like when we were discussing about the citizenship. Okay. So if we talk about it, so when we were discussing about the citizenship, so there was a topic in which we had talked about the loss of citizenship, right? There were certain grounds on which the person could lose his or her citizenship, and one of the ground was acquiring citizenship of any foreign state. Why? Because in India there is only the dual citizenship, which means you could only be a citizen of this country only. Okay. So if you are citizen or not, that is the final question. Okay. So if any member of parliament acquires the citizenship of any foreign state, it means that he will lose his Indian citizenship automatically, right? And we know that to be the part of the parliament, the person must require to be a citizen of India or must holding the Indian citizenship. So if the person loses his citizenship, automatically he will be disqualified as a member of parliament. All right. Thereafter, the second case in it is that if he is not acquired any foreign citizenship, but he is the part of any alliance, or you can say part of any partnership with any foreign state, then the person will automatically declared as an disqualified one. Why? Because it is not allowed. Beside this, if he is so disqualified under any law made by the parliament, like the provisions of Representation of People's Act 1951. Okay, so these are the certain you can say grounds and areas on which the person could be disqualified as the member of the parliament. Okay, the parliament has laid down the following additional disqualification through the Representation of People Act 1951. Okay, like first is he must not have been found guilty of certain election offences or corrupt practices in the election. So, if we talk about it, we know that to maintain the democracy, it is far more important that the elections must be conducted in free and fair manner. Okay. So, if the person who got elected to the parliament, later it was found that the person has adopted some corrupt and manipulative practices to get the votes. Okay, then this will be considered as an election offense, and the person, if he found guilty, he would be disqualified. Thereafter, he must not have been convicted for any offenses resulting in the imprisonment of 2 years or more years, but the detention of a person under the preventive detention law is not a disqualification. Okay, like suppose if there is any person, for example, we had take example of Mr. X. If there is Mr. X, all right, and Mr. X basically commits some crime and offenses through which he has sent to the jail for 2.5 years. So it is more than 2 years. So the person will be disqualified on the grounds for to conquest at the parliament. Okay, but only in the case of punitive detention. Okay, like while we were discussing about the fundamental rights, I had explained you in detail what do you mean by the punitive and the preventive detention. Punitive detention, you can say the punitive detention occurs after the committing of the crime. Okay, like the crime was happened, then the person was detained. But if we talk about the preventive offenses or preventive detention, remember, occurs even before the crime taken place. Okay? Or to prevent the crime or offense before happening. Alright? These are the two terms. So the disqualification for imprisonment for 2 or more years is only applicable in the case of punitive detention. It is not applicable in the case of preventive detention. Why? Because in the punitive detention, the person has committed a crime. But in the preventive detention, the person has not committed any crime or offense. Okay. So if the person was under the preventive detention for more than 2 years, then the person will not be disqualified. He must not have failed to lodge on account of his election expenses within the time. Okay, like it is necessary that whosoever contesting the election, the person is required to disclose his or her election expenses. All right, to ensure the fairness. So if within the lodge time the person fails to declare his expenses, okay, then the person will be disqualified on account of unfair practice. He must not have any interest in the government contracts, works, or services. Okay. Thereafter, he must not be a director or managing agent nor hold an office of profit in a corporation in which the government has at least 25% share. Okay. Because this shows government stakes or partnership in that particular organization. All right. That is the thing. Okay. Thereafter, the sixth one is that he must not have been dismissed from government service for corruption or disloyalty to the state. Okay, like we know, if we talk about the government services, then there are central government services, or we can say there is a three divisions basically for the government services. There are three divisions: all India services, central government services, then comes the state government services. Okay, so if the person was previously working in any of these services, whether in the all India services, central government services, or in the state government services, and he was dismissed from them. Okay, on account of corruption or disloyalty. then the person will be declared as disqualified. Okay. Thereafter, he must not have been convicted for promoting the enmity between the different groups or for the offense of bribery. Like we know in India, the main thing which we are required to preserve is the unity and integrity. Let me write down again this one. Okay, this is the the most basic aim of the Indian Constitution and the Indian political system. So, if the person was convicted for promoting the enmity and destroying the unity and integrity, then the person will be declared as an disqualified. If the person was charged for the offense of bribery while holding any particular office, then the person will disqualify. Thereafter, he must not have been punished for preaching and practicing social crimes such as untouchability, dowry, and sati. Why? Because these are provisions of society or practices of society banned under section of fundamental rights. And beside this, it is also important. Why? Because if the person was doing such kind of things, then after getting elected as a member of parliament, he might be presented the bills or the legislatures to destroying the peace and harmony in the society. On the question whether a member is subject to any of the above disqualification, it's rest with the president and whatever the president decision, that will be the final. However, he should obtain the opinion of the election commission and act accordingly. Okay, it means that the president will declare the person to be disqualified as a member of parliament on the basis of these areas, but he is required to take the advice from the election commission of India. Once the election commission says that this person is disqualified, the president will pass the order to remove the person from the parliament. If the election commission does not pass the opinion to remove the person, the president will not remove the person. Okay, so these are the areas. So students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.